Shalom. We're back with another update to our child support trials and tribulations. I don't know why I get so excited. I actually wanted to be a lawyer. When I was growing up, I started going to school for law, and then I was like, you know what? I don't like school that much. But anyways, we'll get right to it. I want to let you guys know a few things, okay? So let's talk about some of the things I couldn't really talk about on the first video, the really long one where I go through all of his affidavit. Again, we're not lawyers, we're not giving legal advice, we're just sharing with you our testimony in hopes that this can help other people. Let's review a couple things, okay? The 14th Amendment and the 5th Amendment is what covers your due process rights. So you can always challenge your due process rights, and you can always challenge subject matter jurisdiction over any case. Subject matter jurisdiction means that that type of case can be seen in that kind of a court. So family court is a limited jurisdiction. And these arrears are basically a loan. Family court does not have authority to hear court cases about money. It's like that. Okay. Um, let's talk about 28 USC 1691. This is, and you can Google it or look it up, whichever place you want to look it on the web. It's a seal. I think it's called the test of seal. Basically, the documents don't have seals because this is an administrative court. So they don't really have any judicial power. And until you actually contest, then there'll be it's okay and it'll go until you actually question it. If you've left your state, they also don't have personal jurisdiction over you anymore because you don't live in that state, especially when it comes to arrears. But we are specifically challenging jurisdiction and due process and lack of capacity. So if you don't know what that means, jurisdiction means if they can actually see that type of case in that court, that's subject matter. And then personal jurisdiction means that they have personal jurisdiction over you. And if they fail to serve you, which they did in my husband's case, if they failed to serve you, you can also contest it. And there's a lot of other things, as you saw in my other video. If you don't contest it, if you don't bring it up, if you're not advocating for yourself, then it just really kind of goes under the radar. And I know that some people are not happy with me because every single due process violation in my husband's court case, we have directed that to the court and we've brought it to their attention. And we did get a response from child support because they have to respond to the once you actually serve them. And they totally ignored the part that he wasn't served. They just went to, oh, it's a judgment. The judgment already happened. No, it didn't. The judgment is void because there's no judicial seals. So there's no enforcement authority over those documents. And it's also void because he never was served. The other thing that I really want to focus on this video, and I'm going to put up the picture of his original summons and complaint. You can go along with me, okay? So here we go. And this is what we were advised to do by attorneys. So in the original docket here, it was filed, as you can see, in 2006. I think I might have blotted it out. And then on the upper left corner is the people who are suing us, the Superior Court address, the plaintiff, and the respondent and the other parent. Okay, so number one, the other parent was not even listed here. Number two, let's look right under where his name should be. The local child support agency has filed this lawsuit against you. This lawsuit says you and the other parent are the parents of each of the named in the complaint, and that the obligor may be required to pay child support. The attached proposed judgment regarding parental obligations form blah 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 names you and the other parent as parents of each listed below. If there is an amount stated in item 6 of the proposed judgment, orders to the obligor to pay support for these children. If you disagree with the proposed judgment, you must file the attached answer form with court clerk within 30 days of the date that you were served with this complaint. There you go. They even say 30 days that you were served in this complaint. There's no service on file. Okay. If you do not file an answer, the proposed judgment will become a final determination of parentage. If you are required to pay child support, the payments may be taken from your pay and other property without further notice. See the attached statement of your rights and responsibilities. Um, Let me tell you how dumb they are, because right here they're already threatening you. They're already threatening that they're going to take your pay any way they can. So that's already coercion. Number two, they're stating that you have to reply within 30 days of being served. They didn't serve him. Number three, he was in jail. We have proof of that. And so when you're in jail, you have to have an extra timestamp, and the deputy who served you needs to be on file. Yeah, none of the above. So void ab it's called void ab initio. That means void from the beginning. Okay, now if you want to talk about like the rules of the court, let me tell you another reason why this complaint is also void. They did not allege a claim, a cause, a cause of action. They didn't state why they're suing you or what happened in order for them to sue you. If this was a murder case, um, basically they're saying you're already guilty, and if you don't show up, we're just gonna say that you're gonna do life, um, and we're gonna take everything you own until you turn yourself in. That's basically what this summons and complaint says. How child support, and this is where the loss of trust is gonna come with the court. There's we're not gonna trust our legal system, because how did the court allow this lawsuit to proceed when it didn't follow its own procedures? I'm just like, wow. Okay, if you go to page 2, section 3, which they didn't mark because he never signed a voluntary declaration of paternity. That's the birth certificate. When a child is born, dad usually signs the birth certificate, and basically you're signing a contract. They don't tell you that, and they're supposed to do an audio or video and have your signature on file for the VO. It's called a VDOP. But my main thing that I want to tell you guys is that it says voluntary. It says voluntary. Do you know what voluntary means? It means you do it on your own free will. No one is obligated. Guys, you can't make this stuff up. You just can't make this stuff up. It's ridiculous. Okay? And then I won't show you the rest of it because basically nothing happened until September. And then, okay, so in October, a declaration from the child support office came in. So let me tell you that it says that the custodial parent, mom in this case, was on TANF. TANF is temporary assistance to needy families. That's a grant, guys. Give me the definition of grant. Okay, let me give you the definition of grant. And this is Webster's Dictionary. It says a sum of money given by a government or other organization for a particular purpose, emphasizing it is not a loan. Grants are distinguished from debts considered a gift. So, why is anybody obligated to pay that back? Because that's basically why child support is suing non custodial parent. Okay. Okay. One of the things I didn't cover in the last video was paternity. Okay. So, let me take you to, and I'm not actually putting the documents on here. I'm just gonna walk you through it because it just takes too much time. If you want to buy a copy of our documents once our cases are dismissed, I will probably put them up so you guys can see everywhere all the errors. So late in that same document filing in October, they're stating that they want to get a DNA test done. Okay. Well, remember my husband was still in jail. Still in jail. And so here they asked for another hearing, and if your proof of service doesn't show an address, you can state federal guidelines, because this is just saying that they hid the address per family code. Well, the supremacy clause states that federal laws and constitution have a higher standing than local laws. So basically, if you can find a federal code that'll trump your family code, boom, booyah, which we have. And so again, they go on to say that the supporting facts are that mom was on public assistance. Oh, thanks. Okay. By the way, if there's any allegations of paternity tests, you can always contest them. There is a objection of authenticity, and then there's the objection of best evidence rule, where the original needs to be documented. Not only does the original need to be documented, it has to be put in the file in an organized manner. And the actual code says that to to avoid the fact that there's going to be somebody who's going to contest it. So let me give you that code. Rules of Evidence, FRE 103. To preserve a claim or error, there must be a definition ruling on the records. So It has to be in the record, or a reference to it has to be in the record. And these are due process violations. It doesn't mean that you're not claiming your child. It's We're challenging the due process part of it. Okay, this is where ignorance comes in. And it just really depends on the type of people you're dealing with. If mom's going to be offended that you're saying there's no proof of paternity, well, listen, ignorance. um, the challenge is in due process, regardless of what really happened or what happened. The court and child support agency and you are obligated to abide by rules. Okay, so you have to abide by rules. By the way, there is a code, a case law that states that a pro se doesn't have to have the standards of a licensed attorney. People like us who decided to represent themselves, we don't we can't afford a lawyer. So guess what? We're going to defend ourselves and we're going to do the best we can. And the court has to give you that right, and they have to give you some type of leniency because you're not a licensed attorney and you haven't been trained. If they start speaking legalese, you have the right to tell them, I do not understand, and you need to speak in plain English, because it is a disadvantage and that is unfair, and you have the right to a fair trial. Okay. That case law for a pro se's filing is Haynes versus Kerner, 404 US 519, 1972. A pro se litigant's filings should not be held at the same standard as a licensed attorney. Here's another evidence rule you can use in your paternity argument. Federal Rules of Evidence 804B says no admissible evidence was presented to support enforced actions. If they don't actually have it in the documents, they cannot enforce it. There's an obligation by the plaintiff. When somebody sues you, they have the burden of proof. That means that they have to prove you're guilty. You don't have to prove you're guilty. Now, the court is going to say, well, they didn't say they weren't. So, or the child support agency might say that too. Well, they didn't say they weren't, so we're just going to say they are. Or because they're coerced and they're telling you that, well, we're going to take, which they did. They took my husband's driver's license and other stuff. They're kind of like, well, I'm kind of cornered. You don't know how many people I've talked to lately, and I'm really like shocked how some people are like, I really don't want to mess with it. I got it down to this much a month. They're violating your rights. How much do your rights cost? I'm sorry, but there's not enough money in this world to reimburse me for you violating my rights. All right, so we're going to move on to the unconsent part. We kind of talked about it because on my last video, the drug use, California Civil Code 39, they gives you the right to rescission of a contract if you're on mind-altering drugs, either prescription or street drugs. And then California Civil Code 1556 says that someone with an unsound mind is unable to do contracts. And this one is a little different because there's another code that is for people who have mental disabilities, like long-term mental disabilities. This is someone who was kind of mentally unsound at the time. Okay, and then the coercion part, if you can prove that they withheld your license, they garnished you, they they threatened you some way, if you have a recording or on paper, that is coercion, and it's a coerced appearance. And so the tactics of child support have always been, and I really want to start interviewing people who this has happened to. I want to just start interviewing a ton of people of, how did child support get you to go to court? How did child support get you to pay? How did child support get you to say something against your will? Because you're going to find that 9 out of 10 of these moms or dads who are on child support were forced, manipulated, lied to. They weren't told the whole truth. How many times did they tell, just sign here? Oh, it just says that you're gonna pay. That's a violation of your due process. Okay, if they're telling you one thing over the phone and they're not putting it in writing, there's a reason why child support has not responded to us. Not once in writing. Not once have they said what their authority is. You can get a contract discharged when they fail to respond after 3 times. But my husband wants to give the opportunity for the court to rectify it and change it. So we have so many violations that we'll keep going back to that courthouse, and that judge is going to be so sick of us because it's not right. It's not right what they did to him. It's not right what they're doing to others. And so it's important that we spread awareness of these things. If you've been summoned to court for a child support, you right now is the time to act. Don't ignore it. You have to act now. Child support made verbal threats over the phone. And then we wrote in our letters, do not interview, do not call. What did they do? They called. California Public Records Act requires documentation and record of all communication if it has to do with government business. City and San Jose versus Superior Court. That includes phone calls, guys. Make sure you're recording your calls with them. Obviously, per the law, you have to let them know, but record the call. Brady versus US 397, US 742, 1970. Due process prohibits extracting agreements by threats of punishment. Boom. And there's something called the full faith and credit law. That means that wherever that case law came from, by law, each state has to honor it. Johnson versus Zerps 304 USC 458 1938. A waiver of constitutional rights must be both knowing and, here's the key word again, voluntary. Yeah, guys, you have to know your rights. Okay. I'm missing something, I think. Detailed information, rights and review. Okay, so I think I moved this around too much, but there's it's part of their guidelines, I think, this one. And it says that you have the right to review and inspect copies. They have to serve you before garnishing. They never did that, and they don't have proof of it. And like I said in my other video, state secretary's lien search will show you that they don't have it. A failure, oh, here it is. Failure to review 42 USC 666A 10. By the way, if you're a Christian, automatically you should be like, I don't want to do this because their laws are under 666. Last but not least, 31 USC 3720D states that the garnishment has to be taken after disposable income. That includes food and expenses, like livable, the way that you're going to live your life. So if you're on minimum wage and you can't even afford your rent, right there you can get a review. If they've done everything right, they've served you correctly, they've done the paternity test, or you've agreed to the paternity test or the VDOP, then keep every 3 years you have the right to change it. Every 3 years, which by the way, my husband did put in a request to change. It's documented, and it says that he should have gone back to $10 a month of garnishment, and they're taking $188 a month. Yeah, guys, we love you guys. We're gonna pray for you, and we hope to God that this helps you. Here are some questions to. We have 3 minutes left, so here are some questions. Probably gonna cut off. What jurisdiction did you try me on, or are you trying me on? Common law or admiralty? Only lawyers know that stuff, so they're look that up and make sure you know what it means. But they are neither. This family court is neither jurisdiction. Isn't the burden of proof on the plaintiff? Where is the evidence? Why is it called voluntary declaration of paternity? So, why am I being forced to declare paternity? Isn't TANF a grant? How did you get my social security number? That's identity theft. And by the way, if you go in child support under the payments and you click on other party, it's there's a place for you to put the other parent's social security number. Did you give the other parent permission to have your social security number? I think that was it. So I love you guys. Have a blessed day. God bless you.